Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. Where an agent that has been engaged to sell goods is terminated, the agent will generally be entitled to compensation in accordance with the commercial agent regulations. Last year, the High Court ruled that the definition of goods included software and therefore the agent was entitled to compensation. The Court of Appeal has now overturned that decision and said that it will not interpret the term goods beyond its ordinary meaning. The software in this case was supplied electronically. If it had been supplied in a tangible form, the decision is likely to have been different. The Court of Appeal has ruled that legal advice privilege will only apply where a solicitor is providing legal advice. If a solicitor is providing general business assistance, such as arranging insurance for the client's goods, the communications will not be privileged and therefore disclosable to a court. Courts regularly require parties to use reasonable endeavours to do an act. In a recent case, land had been sold to a developer and the contract required the developer to use reasonable endeavours to reach certain conditions within 10 years. If they were achieved in that period, an overage payment was payable to the seller. Perhaps unsurprisingly, the conditions were satisfied just a few days after the 10-year point. Litigation followed, with the seller arguing that the developer had not used reasonable endeavours. The court agreed with the seller, finding that the developer had only progressed things when it suited it and therefore breached its reasonable endeavours obligations. Since October 2009, new directors have been able to keep their residential addresses private by making use of a separate service address on the public records. However, addresses that predated October 2009 have remained in the record, except in certain cases where the directors have been able to show that there was a serious risk of violence or intimidation. New proposed laws that we expect to be enforced by September will allow for removal of all residential addresses from company house records. Once the General Data Protection Regulation, the GDPR, has been implemented, the annual notification requirement to the Information Commissioner's Office, the ICO, will be abolished. However, businesses will still need to pay a fee unless an exemption applies. Draft regulations and guidance on the fees regime is available on the ICO website. This states that the annual fee will be £40, £60 or £2,300 depending on the turnover and number of staff. The ICO has also recently published guidance on record keeping under the GDPR. The record keeping requirements go beyond the current obligations and require businesses to keep full details of processing activities, including who data is shared with, the purpose and security requirements. Companies with less than 250 employees and that only undertake occasional low-risk data processing are exempt from the same record-keeping obligations. When businesses are acquired or services are transferred from one business to another, dedicated employees will usually have the right to transfer to the new provider under TUPE regulations. In these cases, the transferring employees have a right to information and consultation before the transfer. Whilst it's only the transferor company that can ensure this happens, 3 recent cases have confirmed that if it does not happen, the employees can only bring claims against the transferee company. Transferee companies are therefore advised to seek an indemnity to cover this risk from the transferor company. Wagamama, TGI Fridays, Marriott Hotels and Karen Millen are among the companies named and shamed by the government for failing to pay the minimum legal wage. The issue in each of these cases appears to be that the employers have required employees to adhere to casual uniform policies. In TGI's case, staff were required to wear black shoes. If, however, there is any requirement to follow a uniform, then the minimum wage laws require employers to ensure that the net pay after buying such items is still above the national minimum wage. Zero-hour employees and workers have the right to 5.6 weeks paid statutory holiday per year, and a recent case has confirmed that the correct calculation of the holiday pay is the average weekly earnings over the previous 12 complete weeks. Weeks in which no remuneration is earned should be ignored, and employers must only count those weeks where there have been earnings until 12 weeks are taken into account. Employers are not able to choose any different periods. Personal service companies are commonly used by contractors to provide tax efficiencies. Typically, the individual will pay him or herself, and often a spouse who is also a shareholder, mostly by dividends rather than PAYE. In a recent case concerning a journalist who was engaged by the BBC through her personal services company on long-term full-time contracts, the HMRC has successfully argued that the nature of the work meant that she was akin to an employee and should therefore have paid PAYE tax and national insurance on all income from the BBC and not just the sums that were paid to her as salary. It's understood that HMRC's claim exceeded £400,000. The Office of Product Safety and Standards, a part of the Department for Business, Energy and Industrial Strategy, has teamed up with the British Standards Institution, the BSI, to issue a new code of practice for product recall and corrective actions. Whilst it is only a code of practice, businesses that comply with its recommendations are likely to be treated as having complied with their legal obligations. The code has been created in the light of concerns that product recalls have not been effective. A report by Electrical Safety First claimed that electrical product recalls in the UK have an average success rate of just 10 to 20%. The Bribery Act makes companies automatically liable if a person associated with it bribes another. There is, however, a defence if a company can show it has adequate procedures in place to prevent bribery. We have now had the first test of the adequate procedures defence in the case of Arvis Skanska Interiors Limited, SIL. This case concerned a bribe being paid by SIL's managing director to a manager of its customer company to secure a major contract. SIL, a small subsidiary of the Skanska Group with just 30 employees, was successfully prosecuted. It did have some procedures in place, including policies concerning transparency and contract clauses that prohibited bribery, but the lack of any specific anti-bribery policy and lack of anti-bribery training meant that it was unable to show that it had adequate procedures in place. Thank you for tuning in for this month's Commercial Bulletin. For more information on any of these stories, please contact Radius Law or my colleagues at LexisNexis. We'll be back in May with more of the month's key legal updates.